Welcome everyone. My name is Ayushi Jaiswal. I'm working as an assistant professor in the School of Legal Studies, PBD University. This is another lecture in the series of lectures on Criminal Procedure Code. Today's topic is Object, Scope and Extent of the Criminal Procedure Code. Law of criminal procedure is intended to provide a mechanism for the enforcement of criminal substantive law. It is basically a procedural law. Without proper procedural laws, a substantive criminal law which defines offences and provides punishment for the same would be almost of no use. Because, in the absence of enforcement machinery, the threat of punishment held out to the law breakers by the substantive criminal law would remain empty in practice. Empty threats do not deter, and without deterrent effect, the law of crime will have hardly any meaning or justifications. So, the law of criminal procedure is meant to be complementary to substantive law and has been designed to look after the process of its administration. Basically, the Criminal Procedure Code is primary piece of legislation in India governing the administration of substantive criminal law. The full form of CRPC is Criminal Procedure Code. CRPC is passed into law in 1973 and went into effect on April 1, 1974. The purpose of the code is to provide machinery for prosecution, trial, and punishment of offenders under substantive criminal law, that is the IPC, Indian Penal Code, and other various laws passed by the state from time to time. Now, what is the objective behind this criminal procedure? The law of criminal procedure is intended to provide a mechanism for the enforcement of criminal substantive law that we all know. So, the tool for to determine guilt or innocence, collective collecting evidence, try cases, and punish offenders are all provided by this code. In addition to addressing matters of public annoyance, crime prevention, and support of a spouse, dependent children, or elderly parents, the Criminal Procedure Code also addresses similar matters. This act consists of mainly 484 sections, which are further divided into 38 chapters, 2 schedules, and 56 forms. The code provides a uniform set of criminal codes throughout the territory of India by conferring jurisdiction, powers, and functions. The important objective of the code is to provide an opportunity to the accused person to get a fair trial in accordance with the principle of natural justice. Another objective would be to ensure a fair trial where none of the rights of the accused are compromised, nor are they unjustifiably. Their object would be to make an effort to prevent delay in investigation and trial, which ultimately ensures fair justice. To ensure the tenets of any person concerned with the case, including an accused or a witness, through various measures, for example, sending summons, issuing warrants, proclamation, and attachment of property. To provide a detailed scheme to make an effort to prevent delay in investigation and trial, which also ensures fair justice. To provide a detailed scheme for working of various functionaries of the state to help and assist the administration of criminal justice in India for the entire time period between when a crime has been committed until the time the sentence against the crime is passed and the case is finally closed. That is all the three stages: investigation, inquiry, and trial. Now, the importance or the significance of the criminal procedure lies in the fact that it is more constantly used and affects a large number of people than any other law. The nature of its subject matter is such that the human values are involved in it to a greater degree than in other laws. As the law of criminal procedure is complementary to the substantive criminal law, its failure would seriously affect the substantive criminal law, which in turn would considerably affect the protection that is given to society. Therefore, it has been rightly said that too much expenses, delay, and uncertainty in applying the law of criminal procedure would render even the best of penal laws useless, ineffective, and oppressive. Hence, criminal procedure is to be given a little liberal approach while interpreting the same, since procedure is the handmaid of justice and not its mistress. Now, prior to the current CRPC that we are studying, that is CRPC 1973, there was no uniform or effective law of criminal procedure for the whole of India. There existed separate acts, mostly rudimentary in character, which prescribes the procedure of courts in provinces and presidency towns. It was a Criminal Procedure Code of 1861, which was initially enacted to be a uniform law of procedure for whole of India, including the presidency towns. It was replaced by the Criminal Procedure Code of 1882, which also underwent several amendments from time to time, and followed by the Code of 1898. The most extensive and significant amendment was made by the Code of Criminal Procedure Amendment Act 1955. Yet a constant demand was made for the revision of the code. In pursuance of Law Commission report, a draft bill was prepared and was passed by both houses of Parliament, and the present Code of Criminal Procedure came into force. So the evolution of the CRPC can be traced back to 1861, when the first code was enacted. Following the passage of IPC in 1860, following the Muslim imposed law in medieval India, Mohammedan criminal law became the norm. Under the Regulating Act of 1773, which was issued by the British monarchs, a Supreme Court was formed in Calcutta and later in Madras and Bombay. The Supreme Court was required to decide cases involving subjects of the Crown using British procedural law. Following the 1857 rebellion, the Crown assumed control of India's administration. The British Parliament approved the IPC in 1861. The CRPC was initially established in 1882, revised in 1898, and then accordance with the 41st Law Commission report in 1973. Now, what is the extent of CRPC? Section 1 of the code provides for the extent, scope, and applicability of this code. It says it is applicable to the whole of India, provided that the provisions of this code, other than those relating to Chapter 8, 10, and 11, shall not apply to the state of Nagaland, to the tribal areas in Assam. But the concerned state government may, by notification, apply such provisions or any of them to the whole or part of the state of Nagaland or such tribal areas, as the case may be specified in the notification. To conclude, we can say that the code plays a significant role in the Indian criminal justice system, as it ensures that the legal proceedings are conducted in a fair and transparent manner. It provides a framework for the investigation and trial of criminal offences, which helps to safeguard the rights of the accused and ensure that justice is delivered in a timely and effective manner. The code also provides for the establishment of various courts, such as Magistrates' Court, Sessions Court, and High Court, and outlines the powers and duties of each of these courts. CRPC also sets out the procedure to be followed during the investigation, including the arrest of the accused and search and seizure of evidence and interrogation of witnesses. In summary, we can say that the Code of Criminal Procedure is a crucial legal document in India that governs the criminal justice system and ensures that legal proceedings are conducted in a just and fair manner. That's all from my side. Thank you so much.